Namaste to all the participants. Namaste from AAA Insolvency. So today we have with us Advocate Amar Vivek, who is working for some of our cases. And for this research, Advocate Amar Vivek has also done a lot of work. So this is a special episode. And in this special episode, we are only covering one very important judgment, which is from Supreme Court of India dated 30th of May 2022, and the citation is Kotak Mahindra Bank versus A. Balasubramaniam, no, A. Balakrishnan, A. Balakrishnan. So this is actually two main issues which are covered in this judgment, which are actually controversial because of various other judgments from NCLAT and also from high courts. So this particular judgment of Supreme Court has actually finalized these two issues. One, whether this decree or any kind of order of a court would actually become a financial creditor or an operational creditor, number one. Number two, what kind of limitation law is applicable on these orders, decrees. So this is very important. So like we should, Amar, we should share our screen, and then accordingly we'll continue to discuss.
Yeah, sure. So sir, are you sharing the PPT or should I?
Okay. Yes, I am sharing the PPT. So friends, the Supreme Court judgment, Kotak Mahindra Bank Limited versus A. Balakrishnan and others, this is dated 30th of May 2022, and it has been heard by Justice L. Nageshwara Rao, Justice B.R. Govai, and Justice A.S. Bopana. However, this judgment is per Justice B.R. Govai. And the judgment is very important. The appellant, Kotak Mahindra Bank, and the respondent is a suspended director. Respondent is a suspended director. I think I have made some changes, maybe that we've taken again the old one. Anyway, we'll just continue on this only. The A. Balakrishnan is a director with suspended powers of Prasad Properties and Investment Private Limited. So I have made some changes anyway. This is maybe that the old one has just a second. I think I will stop sharing this and we'll see if there is any. Maybe there are two.
Sir, mine one is titled with final.
So I think the one you have sent, you have not considered the amendment which I made. It is in between, or anyway, we'll continue with this now. So the facts that we can give in brief, originally in 93-94, Ind Bank Housing Limited sanctioned loan to 3 borrower entities, and for all the 3 borrower entities, one, Prasad Properties and Investment Private Limited, was a corporate guarantor, and the corporate guarantor has also mortgaged its own properties to secure the loan granted to 3 borrower entities. So while the primary case was in the why the borrower entities are three companies, which are the Green Garden Private Limited, Gemini Arts Private Limited, Mahalakshmi Properties and Investment Private Limited. These were the three borrower entities. However, the respondent in this case, like the corporate debtor, like the banks and financial institution, which is Kotak Mahindra Bank, ultimately they proceeded against the corporate guarantor for initiating Section 7 application for initiating CIRP. So they, in fact, all the borrower entities, they defaulted and they became NPA in 97. And for the recovery of this amount, this Ind Bank Housing Limited filed 3 civil suits before High Court of Madras against against the debtors and the guarantor. During this pendency of these suits, this Kotak Mahindra Bank, in fact, entered into a deed of assignment. So the entire loan was assigned to Kotak Mahindra Bank, and that was in 2006. And all the rights, title, interest, etc., was assigned to Kotak Mahindra Bank. So this was the brief facts. And then see, later on, this Kotak Mahindra Bank entered into a compromise arrangement with the borrower entities, where the amount of about 20 crore was settled, and it was also recorded in the High Court of Madras. But then again, this particular compromise was not honored. It was defaulted, and Kotak Mahindra Bank, they proceeded under SARFAESI Act. Notice under Section 13(2) was given. The notice under Section 13(4) was also given for taking physical possession of the properties mortgaged to the bank. They also, winding up notice was also given under Section 433 and 434 of the Companies Act. So this was all done, like if you see this recovery process that actually continues for many years. And then the default continued, and somehow the possession was also not possible. The winding up petitions were also pending. So in the meantime, the Kotak Mahindra Bank filed 3 applications under Section 31 capital A of Recovery of Debts Due to Banks and Financial Institutions Act 1993. Now this act is called Recovery of the Debts and Bankruptcy Act, with effect from 1st of December 2019, when this individual insolvency was notified. The DRT allowed the applications and issued separate recovery certificates, and that was dated 7th June 2017 and 20th October 2017. So that means the recovery certificate was also issued against the corporate guarantor and also the borrowing entity. That's what it could mean, because the separate recovery certificates were issued. Going forward, based on the recovery certificates, in 5th of October 2018, Kotak Mahindra Bank, claiming to be a financial creditor, they filed an application under Section 7 of IBC, and this application, and they claimed a total amount of approximately 835 crores, which is the original amount, irrespective of the amount settled or the compromise. The case was before NCLT Chennai, and on 20th of September 2019, the CIRP was initiated, and therefore the suspended director preferred an appeal before Honorable Appellate Tribunal. And the grounds raised was, in the appeal, the grounds raised was that the appeal was with regard to the application under Section 7 being filed after the expiry of limitation period, and NCLAT allowed the appeal, and that order of NCLAT was dated 24th of November 2020, and the appeal was allowed, and probably the initiation of CIRP was quashed. Now, therefore, this Kotak Mahindra Bank now is before the Supreme Court against that impugned order of NCLAT, which is dated 24th of November 2020, and in that order, the CIRP was held to be invalid. The initiation was held to be invalid because of the limitation, and also because of the recovery certificate is not a debt. Now, what are the arguments of appellant? So what the Kotak Mahindra Bank said in this case to Honorable Supreme Court. So one, that the issue which is involved in the present proceeding is no more res integra, and as this decision has already been taken by Honorable Supreme Court in the case of Dena Bank, because of the merger, now that bank is called Bank of Baroda versus C. Shiva Kumar Reddy, where it was held that a fresh right accrues to creditor after a certificate of recovery is issued to the creditor to recover the specified amount. So this was what it was held by the Supreme Court in the case of Dena Bank versus C. Shiva Kumar Reddy. And in fact, this is one, it was the appellant said that this is already a settled issue. Hence, the judgment in Dena Bank case is not per incuriam, but a correct and warrants interference. In fact, in this judgment, a lot of the doctrines are being used, and we will try to explain to all our listeners and viewers that how these doctrines are being used in this judgment very, very intelligently. So we will try to explain to our viewers. So the application filed under Section 7 of the Code is within the period of 3 years from the date of issuance of recovery certificate, and the respondents have failed to comply with the terms of the compromise decree. Hence, they cannot propose they cannot oppose the admission of the application. This is what the bank said. So they said that the order of Dena Bank, the Supreme Court order, like Dena Bank versus C. Shiva Kumar Reddy, is not an order. It is not an order which is issued by Supreme Court because of some carelessness or because of some something not brought to the knowledge of Supreme Court, but it is a good, thoughtful judgment, and that matter has already been adjudicated permanently. Then the other arguments of the bank was that the relevant provisions of Insolvency and Bankruptcy Code are construed in correct perspective. The only conclusion that would be arrived at that the Kotak Mahindra Bank is a financial creditor. In fact, the appellant also said that the correct position would be the underlying transaction forming the basis of the proceedings. So it was also explained, like had a decree been issued against an operational creditor, against an operational debt, then the recovery certificate or a decree would also be considered as an operational creditor. However, in case the underlying transaction is for a financial debt, then the decree or the recovery certificate would also be considered as the financial creditor. So the underlying transaction is, in this case, was a financial debt. Therefore, the application under Section 7 is maintainable. However, in case the underlying transaction could have been an operational debt, then application under 9 could have been filed. So the judgment debt does not lose its legal essence. Now, once this person has become, now is a judgment debt. It's a judgment debt, and this corporate debtor has become a judgment debtor. So it does not lose its legal essence or character. No, it's solely because it has fructified into a recovery certificate. Rather, it was argued by the appellant that once the decree is issued, or once the recovery certificate is issued, that means that there is no dispute. That means all the disputes are settled. So therefore, it actually has become a final admittable claim. So now the respondents means the corporate debtor or the corporate grantor, they in fact were saying that this cause of action has merged into the order of issuance of the recovery certificate by Honorable DRT. Therefore, the application is basically the doctrine of merger is applicable. The debt no more survives. You see, like basically the respondent was saying that once a particular recovery certificate or a decree is issued, the debt no more survives. I mean, according to our understanding, the debt is a debt. If it is followed by an order that the debt further gets fructified, it actually gets more strengthened and more firm. The initiation of CIRP by the Kotak Mahindra would amount to filing of the second proceeding. They were saying that the first proceedings were filed before DRT, recovery certificates were taken before DRT. It would have been the only option available with the Kotak Mahindra Bank is to proceed and get this recovery certificate implemented, get the recovery through DRT. However, the filing of the application under IBC is a filing of the second proceeding for the same cause of action. So therefore, it would hit by the doctrine of res judicata, and particularly per rem judicatum. We'll explain these two doctrines, and also the respondents, in fact, said that in view of the limited legal fiction under section 19, subsection 22, capital A of the Debt Recovery Act, the recovery certificates cannot be treated as decree for all purposes. So in fact, section 1922A very clearly says that based on the decree, the winding up applications can be filed by the decree holder. That is what is said in section 1922A of the Debt Recovery Act. Now, assuming that the decree holder may initiate CIRP as a financial creditor, but the holder of recovery certificate granted under section 19, subsection 22 of the Debt Recovery Act is not entitled to initiate CIRP. So, under IBC as a financial creditor or a decree holder. So, holder of a recovery certificate. Now, they were actually trying to differentiate the decree and the recovery certificate, which of course finally the Honorable Supreme Court negated whether the decree or recovery certificate is something different, because see, the argument of the respondent means the corporate debtor or a corporate creditor. They were saying that subsections 22 and 22 capital A of section 19 of the Debt Recovery Act were brought onto the statute book by the Enforcement of Security, Interest and Recovery of Debt Laws and Miscellaneous Provisions Amendment Act 2016. The deeming fiction contained therein applies only for the purposes of initiation of winding up proceedings and cannot be extended for any other purposes. So when this amendment was made, it was mentioned that these recovery certificates can be used for initiating winding up proceedings. And the amendment was in 2016, that means before the IBC came. After 15th of November 2016, the date on which section 255 of the IBC was brought into force. Now, section 255 is basically all the amendments under the Companies Act, which is as per 11th schedule to Insolvency and Bankruptcy Code 2016. Those are basically notified by way of section 255 of the IBC, and section 255 of the IBC followed by 11th schedule of all the amendments in Companies Act 2013. Was brought into the force. The recovery certificate holder lost their right to use their certificate as a decree for initiating winding up proceedings under the Companies Act. So a decree holder cannot initiate the CIRP, because see, when this section 255 of the IBC was brought into force, that section where the winding up proceedings can be started against a creditor who is failed to pay, that particular section was omitted itself. So when the section was omitted, the respondent said that this section 255 led to that section itself was removed from the law, where the winding up proceedings can be started on account of a default. Therefore, the decree holder cannot initiate CIRP, because the meaning of section 19, subsection 22 and 22A for initiating winding up proceedings has itself been completely deleted. So then it was also argued that the judgment in the case of Dena Bank is per incuriam. Per incuriam means that the judgment has actually been given where some of the judgments or the provisions of law was not brought to the knowledge of the court, like subsection 22 or 22A of the section 19 of the Debt Recovery Act, as well as clauses 6, 10, 11, and 12 of the section 3, because these are the definitions of IBC, and also clause 7, 8 of section 5, which is the definitions of IBC in the CIRP chapter. Now, the respondent also said in their arguments that the the provisions of IBC and Debt Recovery Act, which are considered is correct perspective, the conclusion that would be inevitable that the decree holder is not a financial creditor and as such is disentitled to invoke the provisions of Section 7. They also tried to refer moratorium, but which the court in fact negated very clearly in single paragraph. Now the Amar, this particular judgment has used various doctrines of res judicata. See, as a lawyer, how would you make our viewers understand what are the real meaning of these doctrines?
So, the doctrine of res judicata, and particularly how it has been used here, was in reference to the judgment of Hari Govind Dave. So, what the respondent contended that in regards to the judgment given by by the Supreme Court in Gaurav Hari Govind Dave, in which the court clearly held that IBC is not meant to give a fresh new life to the time bar debt. So the court, and in reference to Dena Bank as well, in which the court has said that although it is a new proceeding, but the matter which was decided was that no fresh life was to be given to a time bar debt. So in this reference, the doctrine of res judicata, what it employs is two principles. Firstly, that once there is a sort of conclusiveness that is to be attained, and the second thing is that the interest of the individual should be protected from multiple litigation. Now, what is res judicata in principle? That first one is the finality and conclusiveness of the judicial pronouncement. If a particular set of question of law has been decided by a particular court, then that question of law cannot be revisited by the same court unless and until there is a material change in material fact of the whole question of law. So in this case, what they wanted to say is that this question of law, that a fresh extension of timeline is not meant under IBC, has been decided, and while a recovery certificate goes against this question of law. However, the Supreme Court in this has held that, surprisingly, which sir, we will come to a later point, that the res judicata does not apply here, because the set of question of law is altogether different and it needs reconsideration.
So, Amar, you mean that's the judgment of Dena Bank, where
Yes.
it was held that the limitation law is applicable on all the cases where the recovery certificate is issued, and there is a fresh life which is granted to the debt on issue of the order or issue of the recovery certificate, and that particular order in Dena Bank that has already achieved finality, and there is no case which is made by the respondents that it should be examined afresh. So this particular issue has already been subject to the doctrine of res judicata. So there is no need to discuss this particular issue further.
Correct.
This is what exactly is applicable to the judgment of Dena Bank.
Correct.
Right. So this is very important because these doctrines or these words are used for emphasizing a particular scenario, and rather than writing 15 pages about a scenario, if simply a doctrine, name of the doctrine is mentioned, I think this actually makes everyone understand it better. Now, the second doctrine which is used in this judgment is the doctrine of per rem judicatum. So what exactly would you like to share with your viewers?
So
in this regard?
In regards to doctrine of per rem judicatum, it is an extended version of doctrine of res judicata, which we also in other words speak that it is constructive res judicata. So this doctrine was in elaborate manner was explained by the Honorable Supreme Court in case of State of UP versus Nawab Hussain. So there was a case in which the court held that you cannot come in a suit, in the same suit, with a new set of facts, with a new defense that ought to have been raised in the earlier suit. So they said that whatever is to be raised it has to be raised on the one instance always. It cannot, you cannot come with new set of new defenses in every new suit before the same forum. So this constructive res judicata bars a litigant from bringing a new defense under the same suit in a same forum.
So I
So
think the Supreme Court has also tried to lay down the pillars of this doctrine, and they're saying that this finality and conclusiveness of judicial decisions for the final termination of disputes in the general interest of the
so
community as a matter of public policy. This is what is the
correct, sir.
holding something as a doctrine.
So
And
just adding a little bit here. So in this, if you we were just going through the contention of the respondents that were these sections 19 to 1922 and 1922A and other sections of IBC were not considered in Dena Bank. So the court said that the doctrine of res judicata clearly applies and it has been considered by the court. You cannot come up with a new defense and say that the judgment is per incurium.
yes, yes, I think this is again the this doctrine of per incuriam is also been used in this order. I think this also can be explained with little more ease to our viewers. Amar.
So, sir, as I was referring to doctrine of res judicata, that how respondents contended that the Dena Bank case was per incurium. So this doctrine of per incurium says that there was any act of ignorance. Suppose there is a already existing judgment of Supreme Court on any question of law, and the High Courts, or for that matter any NCLAT, rules any question of law against the order of Supreme Court, then that judgment of the subordinate court is said to be per incurium. As we have a very recent case in which the judgment of Manoj Kumar Agarwal was said to be per incurium in a subsequent judgment by NCLAT of Kiran Shah, wherein it was decided that the same question of law has been decided by Calcutta High Court in a different matter. So it is simply a doctrine wherein the court is said to have ignored a certain set of facts or question of law, and the judgment is a nullity in that case. So in the instant case, what happened that the respondents contended that sections 22 and 22, section 19 subsection 22 and 22A of the RDBI Act has not been considered. Similarly, sections 5, 6 and 7 of the IBC have not been considered. The Supreme Court clearly said that it was not carelessness, and per incurium does not apply here.
I think this is very clear that there was no inadvertence, there was
Exactly.
no ignorance, and all these provisions were brought to the knowledge, and there is nothing which has been brought to the knowledge of the Supreme Court which actually proves that this judgment was per incurium. That's what the doctrine. So I think this is really interesting, Pawan, that we actually discuss these doctrines which are very carefully used in this order by Honorable Supreme Court. So there are the various judgments which are referred to in this judgment, I think, which is the basis of this judgment. And the first is this Dena Bank versus C. Shiva Kumar Reddy, and this is also 2021 Supreme Court judgment. The issues before that particular application, the petition, whether the petition under section 7 of the IBC would be barred by limitation on the sole ground that it has been filed beyond a period of 3 years from the date of declaration of the loan account of the corporate debtor as NPA, even though the corporate debtor might subsequently have acknowledged its inability, liability. The second issue was whether a final judgment and a decree of the DRT in favor of the financial creditor or a recovery certificate would give rise to a fresh cause of action to the financial creditor to initiate proceedings under section 7 of the IBC. Third issue was whether there is any bar in law to the amendment of pleadings to the file additional documents in a petition under section 7 of the IBC. So these issues were in fact there in then the observations made by the Supreme Court, and what was held by Supreme Court was as such, like section 7 subsection 2 to subsection 5 of the IBC read with The 2016 NCLT rules do not bar the filing of the documents at any time until a final order, either admitted or dismissing the application, has been passed. The second part of the held portion was the time stipulation of 14 days in section 7 subsection 4 to ascertain the existence of a default is apparently directory and not mandatory. The other part of the held portion, as per section 18 of the Limitation Act, an acknowledgement of present subsisting liability made in writing in respect of any right claimed by the opposite party and signed by the party against whom the rights is claimed has the effect of commencing a fresh period of limitation from the date on which the acknowledgement is signed. Such acknowledgement need not be accompanied by a promise to pay expressly or even by implication. However, the acknowledgement must be made before the relevant period of the limitation has expired. The other observation, which is actually more relevant to this particular case, is the referring to the observations made in Faro Alloy Corporations Limited versus Rajhans Steels Limited. The Honorable Court held that order or a decree of DRT and the recovery certificate in favor of the financial creditor would give rise to a fresh cause of action for the financial creditor to initiate proceedings under section 7 of the IBC for initiation of the CIRP within 3 years from the date of the judgment or issuance of the certificate of recovery. This was held in Dena Bank versus C. Siva Kumar. Again, it was held that on a conjoint reading of provisions of IBC, it is clear that a final judgment or decree of any court or tribunal or any arbitral award for payment of money, if not satisfied, would fall within the ambit of a financial debt, enabling the creditor to initiate proceedings under section 7 of IBC. So, Amar, I would again focus on final judgment, decree of any court or tribunal or any arbitral award for payment of money. So that means the when this consumer court, the NCDRC or state consumer forums, when they are issuing they are issuing orders under the Consumer Protection Act, that means that is also an order. So therefore, that also would be considered as a fresh start of the fresh lease of the period. And also when a decree can be considered as a debt, therefore an order also can be considered as a debt. Therefore, the judgment or order or even the order under RERA for home buyers, these are also considered to be a debt now. So what is your thought about it?
Sir, that's why we need to identify the difference between an order and a decree. So a order may be a non-speaking or a speaking order. It may not determine rights of the property of the parties involved in a conclusive manner. But when we say a decree, so decree is a conclusive determination of rights of the parties in the suit. So when we say conclusive determination, means the court has decided whether there is a debt involved or not. In an order, so that's why there is a consciously use of the word decree and judgment or award or payment of money. So we see that the on the last 4 lines of the PPT, it has been reproduced that a final judgment or decree of any court or tribunal or arbitral award. So judgment can also create a right in favor of the judgment debtor. Similarly, a decree creates a right in favor of the judgment debtor, and an arbitral award in a similar manner does so. So these decrees always create a new right in favor of a person in whose favor the judgment or decree, as the case may be. So therefore, a fresh lease of life is always given, so that this right has been accrued at this instance, so it will always have a fresh lease of life. So that is the rationale.
So what exactly you think that this RERA order of refund, when the RERA issue a refund order in
Yes.
favor of a home buyer,
Hmm.
would that be considered as a judgment or a decree or a tribe or an arbitral award, or what exactly would that be?
Sir,
Because see, the word used here is final judgment. Is that a final judgment when a RERA passes an order?
sir, correct, sir. So when we see that under Section 40 of the RERA Act, it has been clearly said that the order for the recovery under RERA shall be executed under the provisions of land revenue as act as a under the provisions of land as areas of land revenue under the provisions of Land Revenue Act, and a recovery certificate is to be issued. Now we can come to the Revenue Act, Recovery of Revenue Act. So the Recovery of Revenue Act under Section 3A clearly signifies that a certificate is to be issued in regards to any recovery under an order. The moment a recovery certificate is issued, therefore a debt accrues at that point of time, and a fresh lease of life is given from that point of time when the debt accrues in terms of Article 137 of the Limitation Act. Hello. 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 Sir, were you able to hear me?
So Ankit has also joined, and I believe
Everyone.
Ankit, yes, Ankit,
Hello, sir.
you also
Good
here.
afternoon.
So uh, Advocate Amar Vivek is also here. So we are discussing uh, some part of it. I'll again share my screen with you, and we'll continue the discussions. So this is where we are, Ankit. So we are trying to understand the judgments, various judgments used in this order, which is Kotak Mahindra Bank versus A. Balakrishnan. So
Right.
the other conclusions which are given by Honorable Supreme Court in this Dena Bank versus C. Sivakumar Reddy, those conclusions are: once a claim fructifies into final judgment and order or decree upon adjudication, and a certificate of recovery is also issued authorizing the creditor to realize its decretal dues, a fresh right accrues to the creditor to recover the amount specified in the recovery certificate. This is the final outcome of this judgment of Dena Bank versus C. Sivakumar. The judgment or decree for money passed by Honorable DRT or the issuance of a certificate of recovery in favor of the financial creditor would give rise to a fresh cause of action for the financial creditor to initiate proceedings under Section 7. CIRP can be initiated within 3 years from the date of judgment and or decree from the date of issuance of the certificate of recovery if the dues of the corporate debtor remains unpaid. So this is a good judgment. I think Amar, you can also say something about this Subhankar Bhaumik versus Union of India.
Sir, in this Shubhankar Bhaumik versus Union of India, the Honorable High Court of Tripura was faced with a question that under section 310 of the code, this other creditors, we can include decree holders or not. So what the conclusive judgment of this court was that the decree holders per se are not financial creditors, though although they can be considered as creditors, other they can be classified as other creditor. So the observations were to point out a decree signifies a claim that has been judicially determined and in that sense is an admitted claim against the corporate debtor. IBC rightly categorizes a decree holder as a creditor in terms of section 310. Execution of such a decree is, however, subject to fetters expressly imposed by the IBC, which cannot be whisked away. Once a decree holder is recognized as a creditor, all the provisions of the IBC that apply to creditors, including the waterfall provisions, are applicable in all their force. But however, the same
So,
question which was put
yeah.
across to the court, that whether decree holders are financial creditor, the court answered in negation that decree holders are not financial creditors per se under section 5.8 of the code,
No, I
although
think
they
this
are
is very
creditors.
clear.
Hmm.
This is very clear that the decree holders are not financial creditors because everyone, the transaction underlying the decree has to be seen. And if the
Exactly.
transaction is a kind of operational
Hmm.
debt transaction, then it will actually be
Hmm.
seen under the waterfall arrangement as per section 53. It cannot be said that even if the dues pertains to the statutory authorities or workmen, or it pertains to the persons who have supplied goods or services to the company, so they all will become financial creditors. That cannot be concluded. So the
That
court,
cannot.
in fact, made it very clearly that the underlying transaction and the
Hmm.
original legal status of the transaction will continue
Hmm.
remain unchanged. However, the decree as such is, it can be considered as an admitted claim,
Okay.
admitted debt, and
Hmm.
accordingly section 9 or section 7 application can be filed.
Hmm.
This is what finally it is held. So this
Hmm.
is the so I think the Jignesh Shah and others versus Union of India, it was like a 2019 judgment of Supreme Court. This was
Hmm.
also used in this order, and that's only for the limit period of limitation for making an application under section 7 or 9 was 3 years from the date of accrual of the right to sue, and that is the date of default. So it was the, I think this was the first judgment on the limitation, and after that, now this date of default or right to sue, and now we say that even if there is a decree, then this right to sue or the date of default, that actually gets extended or gets renewed. Although this judgment Jignesh Shah. Now this
Hmm.
Gaurav Haru Govind by the way versus uh, Asset Reconstruction Company India Limited, means ARCIL. In this case also uh, the Honorable Supreme Court observed in 2019 that the time of limitation would begin running from the date on which the IBC code was brought into force.
So this was the
Yes,
contention that was placed. In this case particularly, this was the contention placed before the Supreme Court that the time a fresh new lease of life would be given to all the debts once the IBC comes into picture. So as we see that the court examined its earlier observation in BK Educational Industries case and said that the IBC was not meant to give a fresh new lease of life of debts which are already time barred, and the limitation would apply in terms of Article 137 of the Limitation Act, which is 3 years from the date of default.
yes. So I think this was negated by the Supreme Court, that the fresh date of default would start on the commencement of IBC. So that's negated by the IBC. So the law stays like as the 3 years from the default, or 3 years from the acknowledgement of debt, or 3 years from the decree, or 3 years from an order, or 3 years from arbitral award. So all this is basically 3 years from all this. So acknowledgement of debt, part payment of debt, decree, or so all these are basically the limitation laws. 3 year is final for the IBC. I
That's
mean, normally in case we see for implementation of a decree,
mm,
it is considered to be 12-year period.
Correct, sir. Correct,
for
correct.
implementation of a decree. However, for IBC, because of this Jignesha, it is reduced to 3 years.
Correct.
I think because otherwise like when the decree was issued to under this the Debt Recovery Act, so that decree is valid for implementation, for recovery of dues, and uh, for enforcement of recovery certificate. That was 12 years.
That is
For filing of application, it is reduced to 3 years.
correct.
So it's very clear that the 3 years was, in fact, it was set by Supreme Court under the Jignesha, and then again it was negated that from the commencement of IBC, from the notification of IBC, that was also negated. So now finally in the BK Educational Services also, it was held that the limitation law is applicable for section 7 and 9 applications, and the article 137 of the Limitation Act gets attracted. And if the default has occurred over 3 years prior to the date of filing of the application will be barred under Article 137 of the Limitation Act. So the Insolvency and Bankruptcy Act initially did not have the limitation clause.
Correct.
It was added later. So it started with the Jignesh Shah, and then it started with BK Educational. It started with BK Educational, then Jignesh Shah, and then finally the section 5 of the Limitation Act may be applied to condone the delays for filing such applications. So far we have received Supreme Court judgments. Number 1, acknowledgement of debt in the balance sheet is also considered to be the acknowledgement, so that gets an extension. Then the part payment also gives you extension. And third is the any decree or any arbitral award also gives you an extension. And any kind of application that you have filed in an incorrect jurisdiction, that also gives you an extension. So what are the other things which you recall where the limitation gets extended? 4 things that I could recall. That's
Sir,
like
sir, I would it is a golden triangle of section 137, 14 and 18, which works in IBC majorly. Section 14 of the Limitation Act says, if you are pursuing as a bona fide litigant at the wrong forum, then it has to be excluded. Then again you come to from that date you come to Article 137, 3 years fresh. Then section 18 says there you have an acknowledgement. Then again you have fresh life of 3 years as per Article 137. Then lastly you come to 137. If you have none of the above, then you clearly have only 3 years from the date of default.
Right. So going forward, and we perceive the time also, we have to remain within plus minus 10 minutes of 1 hour. So the Pioneer Urban Land and Infrastructure Limited versus Union of India, again 2019 judgment, which was trying to define the scope of section 5 subsection 8, that means the financial debt. So it started with the real estate case where assured returns or the committed returns are given by the developers, and whether that would actually mean commercial impact of borrowing or not. So this particular Pioneer judgment in fact said that when we see the section 5 subsection 8, and when we start with the sub clauses A to H, it is basically starts with the word includes. So it is said that it is basically the list is it is not exhaustive, it is inclusive. So if it is a list is an exclusive, so nobody can say that any other thing cannot be added. So therefore the decree or any order, any kind of that amount can further be added to the definition of financial debt under section 5 subsection 8. That's what the Urban Pioneers Act said. So these are some of the sections which has been used because like section 19 subsection 22, section 19 subsection 22 capital A of Recovery of Debt Due to Banks and Financial Institutions Act 1993, which is now been changed to Recovery of Debt and Bankruptcy Act. So these two sections, one that the section 1922 says that the presiding officer shall issue a certificate under his signature on the basis of the order of the tribunal to the recovery officer for recovery of the amount of debt specified in the certificate. And the subsection 22 capital A says that the recovery certificate issued by the PO under subsection 22 shall be deemed to a degree on an order of the court for the purpose of initiation of winding up proceedings. This was also the argument that this is winding up proceedings, and the winding up proceedings section has been deleted completely by the Amendment Act. So this particular section 19 capital 22 capital A cannot be applied, and it cannot be seen in the same spirit. That was also the argument. And also the definition of claim is discussed, creditors, debt, all these definitions are discussed, default, financial creditor, and also section 14, like, which is the all these discussions and all these sections were discussed. Now, see, tell me something which is very important about this paragraph 77 and 78 of the judgment, which is talking about what is the definition of recovery certificate, what exactly it is. Because see, the paragraph 77 of this judgment, the Honorable Supreme Court has observed that from the plain and simple interpretation of the words used in subsection 22 capital A of section 19 of the Debt Recovery Act, it would be amply clear that the legislature provided that for the purposes of winding up proceedings against a company, etc., the recovery certificate issued by the presiding officer under subsection 22 of section 19 of Debt Recovery Act shall be deemed to be a decree or order of the court. It is thus clear that once a recovery certificate is issued by the PO under subsection 22, in view of subsection 22 capital A of section 19 of the Debt Recovery Act, it will be deemed to be a decree or order of the court for the purposes of initiation of winding up proceedings of the company, etc. However, there is nothing in subsection 22 capital A of section 19 to imply that legislature intended to restrict the use of the recovery certificate limited for the purpose of winding up proceedings. So this is the argument was negated by the NCLT. So therefore, in the other paragraph, it would be the court held that it would be difficult to accept that legislature intended that such a recovery certificate could not be used for initiation of CIRP, which would enable the corporate debtor to continue as a going concern and at the same time pay the dues to the creditor to the maximum. So when this winding up, which is considered to be more severe and more harsh in nature, so if the winding up can be initiated based on the debt recovery certificate, why not CIRP, which is not even winding up, which is to keep a company as a going concern and also to maximize the value. So this was what is held. Now coming to the final, and then we will take questions, and Ankit can also start reading the questions in the meantime. The first question which the Supreme Court has discussed in this is, would the issuance of a recovery certificate trigger the limitation period? The answer is yes. The recovery certificate would give rise to a fresh cause of action. It can thus be seen that Honorable Supreme Court observed that the issuance of recovery certificate injured effectively and completely the appellant's rights, and therefore the limitation would begin from the said date. In fact, this court observed that the issuance of recovery certificate could trigger the limitation. As such, in our views, this court is in the case of Dena Bank, and it's like the Dena Bank again has been considered while saying this. And the second question was, would the recovery certificate issued by the DRT allow the judgment debtor to initiate CIRP under section 7? Again, the court said yes, the recovery certificate would fall within the ambit of financial debt, and it is covered under the clauses A to H of section 8. That's what the court said, and there is, because that is inclusive. So what are the other controversies which actually gets settled with this order, Amar?
So one of the major judgments that we came across in the year 2020 was in the Sushil Ansal versus Ashok Tripathi, in which the NCLAT held that the recovery certificate, it cannot be used under RERA, which has been issued under RERA, cannot be used under to initiate section 7 of the code. Now, after this judgment, there are 2 points that are settled in regards to the NCLAT's observation, in denial to the NCLAT's observation. The first thing, that when we see the decrees, recovery certificate is issued under RERA. Now, recovery certificate is issued under RERA only in pursuance to a order for recovery of dues in terms of section 40 of the RERA Act. Now, this recovery certificate is to be is executed, and these dues is to be recovered as revenue areas of the Land Revenue Act. So the moment it occurs, it is a debt. It is a why it is a financial debt now? Again, sir, as you have correctly mentioned, the color of the transaction is always to be kept in mind, that the transaction initially of an allottee is a financial debt, comes under section 5A. And subsequently, if not, in case we do not allow such a recovery certificate for initiation of section 7, then certainly we will be going against the judgment which is today in our consideration.
Good. I think now we only can see the new question which is coming in our mind is that now when we come to allottees, allottees are a class of creditor under the IBC. And now in case an allottee has got an order from RERA or from any consumer court, or for that purpose from any other court for a order where the company, the builder, is directed to make a payment of rupees so and so, and if that payment is more than 1 crore, now would this particular person who has an order or a decree in hand, would he be considered as an allottee under under section 58F, or he would be considered as a financial creditor and he would be able to file an application under section 7 against the builder? So this is an issue which now it is coming in our mind. According to our understanding, now since the decree or an order from RERA or an order from consumer court, that can be considered as the one separate order, it is the admittance of the debt, it is the finalization of the debt. So a separate application can be filed, because a person who is holding such order cannot be considered as allottee. The definition of allottee under RERA is different from the status of a decree holder. Therefore, we feel, yes, please.
So just adding to that one point, so suppose if a person has a refund order, and the moment a refund order is given, the builder buyer agreement in nature, in principle, comes to an end. Then even in that case, we cannot consider that person as an allottee.
So I think this opens up a new controversy, whether all these home buyers where the total order obtained from any court is more than 1 crore, maybe inclusive of interest, whether that actually will become a financial debt, and whether they would be able to go solely, they can proceed against the builder under section 7 or not. That's one thing. So I think we finished our PPT. So Ankit, in case you can read out, because I think we have seen some of the people, they were asking some question, or they wanted to ask some question. In case you can think.
So I can see that basically there are no questions per se in the chat box. I don't see any question in the question and answer also.
So they have sent to hosts. I have 2-3 questions.
Yeah, you can have a look at it.
Yeah, the first one is that advance for land purchases with a condition that if the land could not be transferred for any reason, then CD is liable to return the amount with interest 9% per annum. Thereafter, the CD fails to transfer the land and FC filed a suit. Thereafter, High Court gives a decree. So in that case, decree is a financial debt or not?
No, even otherwise, in case we see this section 5, subsection 8 and clause F, any amount paid as advance, any amount paid as advance, and that actually would be considered as a financial debt, although there are controversial judgments on it, whether that actually fructifies into generating working capital, and whether that has a time sense or not. These two things are controversial, but yes, any decree, underlying transaction seems to be a financial debt. So this decree would be considered as financial debt according to our understanding. Of course, there is a controversy in the different judgments, because when we read section 5(8) clause F, it is slightly controversial, because an advance given for purchase of the land may not have two components of this definition. One component is the time value of money, and the second component is that should work as a raising of working capital. So these two components may not be there. Therefore, this controversy would remain till the time there is a specific adjudication on this.
So then there is Rajkumar Mehto. He's saying that issues on limitation act could be elaborated in sequence. Like I think he needs another webinar on limitation act.
We
and
have
IVP.
done that, and we have it on a AAA insolvency YouTube channel. You would see one special session on limitation law as applicable to IBC. If you can go through that, you would actually get the clarity.
So then there is one question, last question. In which form they will be entitled to file form, the decree holders?
No, this is in case I said that in case the underlying transaction is operational debt, then the form applicable to Section 9 application. And in case the underlying transaction is a financial debt, then the form applicable to financial debt.
Okay, that's all.
So I think we conclude this session, and it's like timely completion, not more than 1 hour that we have said. So we do remain connected with us. We will continue our efforts to again get connected with you every Sunday at 4 p.m. and we will bring the new subjects which we think. In case you also have some ideas in your mind, and in case you need that we should do some research, do write to us, do email to us, do send a WhatsApp message so that we start preparing on those subjects also. Thank you very much. Thank you very much.
Yes, sir.
Thank you, everyone. Thank you, everyone.